Hi everyone, my name is Angela Achieng Ochieng. I am the founder and visionary of Sheria Clinic. I'm also an advocate of the High Court of Kenya. Welcome to another episode of Sheria Clinic. Before we start, I'd like to give special shout out to three companies. First, Dolebs Media for the production. They're the ones doing the whole of the production this would be our fourth episode. I would also like to appreciate Print Mzuri Apparel. They do our t-shirts. I'll show you one of them. Then Laurel Haven Abode. This is where it's an Airbnb and it's where we have been hosting all our sessions. So today, as at the time of recording, is 26th April, and it's normally recognized worldwide as World Intellectual Property Day, and that is what we're going to be talking about today. I'm not alone. I'm joined by a good person, a special guest. He's called Brandon Omondi. I'll introduce him before I let him say a few things, then we start. So his bio is very interesting. It's long and beautiful. He's very capable and he knows his stuff with regards to IP law. So he's an advocate of the High Court of Kenya. He's the founder of Brandon and Associates Advocates. He is the lead counsel in IP law at the Center for Afro-IP Law and Policy Research. He'll tell us more about that. He is a certified copyright practitioner, having earned a certificate in copyright law from Harvard Law School. And Bakan, this one will tell me how to say it. Bakan Klein Center for Internet and Society. He holds a certificate in patent law and global health from Harvard Law School and WIPO. WIPO stands for World Intellectual Property Organization under the UN. Number 6, he holds a bachelor's degree from the Moi. I don't know if it's there. I don't know. The Moi School of Law. And he's also an alumnus of the Miranda High School, celebrated Miranda High School. So today the world is celebrating World IP Day by the organization called WIPO, which stands for World Intellectual Property Organization, which is under the UN. And today the theme for the IP is Feel the Beats. It's all about music, art, creativity, and the like. So before we officially start, I'd want Brandon to say something, particularly also with regards to the legal clinic that is coming up with your company. You'll tell us more about that. On to you, Brandon. Tell us more.
Thank you so much, Angela. My name is Brandon Omondi. I'm an advocate of the High Court of Kenya, as Angie has mentioned. I practice law as an advocate at Brandon and Associates Advocates. I'm also the lead consultant in IP law at the AIP Center. I believe much has been said by Angela, so we can get right into it.
But there's something about the free legal clinic.
Oh, okay.
You wanted us
I thought we'd introduce that at a later stage.
Okay.
But on 15th of May, up until 15th of June, we intend to have a free legal aid touching on intellectual property law. So this is open to creators of musical works, artistic works, inventors. We are going to be giving you free legal counsel regarding your craft and everything that pertains to what you do. Right. This entails registration of your IP rights, enforcement, review of contracts, and any other questions that you may have. So between 15th of May and 15th of June, we have a whole month of free legal counsel. Right. So Brandon, please tell us, my viewers are there, our viewers are there. How did you get into IP law practice? What inspired you to get into IP law practice? Well, my interest in IP law was intrigued from the time when I was doing my undergraduate. We had a very interesting lecturer called Valerie Mungari, and she sparked the flame of IP law in me, where I was quite interested in how musical work and artistic works generally can be leveraged to the benefit of the creators.
Okay.
So until that point, I was so inspired that my dissertation was in intellectual property law.
Wow.
Subsequently, I've written a few papers on intellectual property law, specifically copyright. And over time, I've had the opportunity to practice IP as an advocate, where I've assisted different individual clients, corporate clients, in their quest to safeguard their IP rights.
Nice.
So that has been, in a nutshell, the journey of me and intellectual property law.
Would you like to do a master's in that?
Hopefully within the next few months, we should be working on that.
All right. So you can see our guest speaker today is an expert in IP. He's a IP law guru, just to say. So what is IP? Maybe for our viewers, people who are seeing us for the first time, what is IP? You can explain it in very simple terms. And what is the significance of IP rights? Yes, in Kenya.
Well, intellectual property, basically, in a very simple way, these are just intangible assets that arise out of your ingenuity or your creativity. That is intellectual property. Now, intellectual property rights are the bundle of rights that come with such creativity or such products of your creativity or ingenuity.
So now I'd maybe want to ask, what are the main types of IP in Kenya right now? And you can give us examples. Even I know people know copyrights, but then there's a way people confuse trademark and I think patent. They confuse patent and industrial design and copyright as well. So maybe you can explain that to us. What are the types of IP and examples, and how do we not confuse the two?
Well, that is quite true, whatever you observed. Personally, as I have engaged with the creators and the inventors, and generally everyone, you always hear people saying that they would like to patent a certain name, or encouraging people to patent. For example, I think at some point when Steve Osimpo Boy was trending, people were telling him online to patent the phrase Dio Manaki. But no, that is not how things work. You cannot patent a name. And now that's important because that's what we are talking about. So for the types of IP, we have copyrights, for instance. Now, copyrights, the rights that are given to, or rather, rights that are conferred to creators of artistic and musical works, basically. So, for instance, if you have a painting, or you have music, or you have this podcast, or you have a radio station, any work that you're going to be creating out of that is protectable under copyright law.
And if I'm an author, I've written.
Yes.
Okay.
Take, for instance, you write books, for instance. As the author, you are conferred with copyright. And I think one thing we need to mention with the viewers is that copyright subsists immediately a work is created.
Okay.
Some may even argue that copyrights subsist during the creation of these works. So whereas they subsist immediately, it's very important to register your copyrights. This is very important in terms of enforcement. When you register a copyright and you've been issued with a certificate, it will assist you in terms of proof of ownership. It will also assist you in terms of whenever there's a dispute regarding that particular work.
I'd maybe want, still under copyright, maybe you can explain to us, where do we register copyrights, or which government office am I registering the copyright?
I know many lawyers would hate to hear this, but the registration of copyrights is quite simple, and you can do it at the comfort of your own house. You just log in, and then you look up National Rights Registry.
National Rights Registry. So it's not eCitizen?
It's not eCitizen.
Okay.
You go to Google, look up NRR, that is the National Rights Registry. The first link you see on Google, you click upon it. I believe it's nrr.copyright.go.ke. And it's a very simple process. They are prompts. You just upload the works that you need to be protected with. And then I guess the fee is 1,000 shillings. So that is quite affordable. So, I mean, you can do it alone. You do not need
an advocate.
You don't need an
But you'll still need us somewhere. Don't
But
worry.
at some point, you are going to need an advocate for matters of enforcement in terms of dispute resolution. But just for a start, and as you need, or rather as you seek to register your copyright, this is something you can do yourself.
All right.
And it can be in relation to many things. It can be in relation to a book or a painting or a picture. And many people don't know this, but even dancers can register copyrights in respect of their choreography. We
see so many dancers on TikTok. I hope they'll see this video.
And yes. I would strongly encourage them. Because honestly, some of these dancers, they create very nice challenges. And then these challenges at some point are exploited commercially. So you understand, one dancer creates a choreography and then it goes viral. And then someone else comes, takes that choreography and exploits it commercially. Understand? Now in that aspect, the original creator of that choreography has not benefited.
True.
However, if you register your choreography and then someone exploits it commercially in future, you're able to claim.
All right. When you talk about still commercializing it, for instance, there's a song out there, people have danced and it has trended, and this musician decides, okay, I want to make a video, and then instead of making and they want to include the choreography that was trending, and they don't tell this person, and then now are you getting what I'm saying? Yeah. Yes, so yes. I'm looking at it that way. So you're saying that if it's already registered, and I'm the musician and I want to produce a video and use the same choreography, I need to reach out to that.
You need to reach out
to the dancers
original
or to the choreographer.
You need to reach out
and
to
pay them, or
of course you have to pay them.
Okay.
Yes. One aim of intellectual property law is to encourage innovation. Okay. And one way of encouraging innovation is to reward the artist.
Okay.
So ideally, if you need to exploit any aspect of any person's intellectual property, you have to pay them.
Okay.
So I believe that now will encourage them to do more.
More.
Yes.
Maybe you can tell us about patents. What are patents?
Patents are basically legal rights conferred upon people who invent industrially applicable, non-obvious, novel inventions. Okay. So, for instance, and I guess now I have to give this example for the viewer.
Yeah.
Let's assume one day you wake up and then a brilliant idea hits you. You have come up with an idea of making a machine that can prepare 1 million chapatis per day.
I see where you're going.
You are going to protect that under patent. In the sense that now the requirement for patentability is that, number one, it has to be new. Now this chapati making machine, it has never been seen anywhere. So it's new. It satisfies that aspect.
Okay.
The second aspect is industrial applicability. Now we have in the culinary industry where people now cook and prepare meals in large scale even, it's industrially applicable in that sector.
Okay.
So you understand? It is new, it is industrially applicable, and lastly, it is not obvious. I mean, not many people wake up and think, even the chefs, well-renowned chefs, even well-renowned engineers, not everyone wakes up every morning and thinks that I want to make a machine that makes 1 million chapatis per day. Okay. You understand?
Yeah.
So there's that non-obviousness, there's the novelty, and then there's industrial applicability. So if a viewer listening to me, if you have an idea that satisfies all those three aspects, then it's protectable under patents. And let me just go back. When you let me go back to copyright.
Copyright, right.
Once you apply for registration under the NRR, you are going to be given a license by the NRR through the Kenya Copyright Board.
Yeah.
And for patents now, whenever you need to register a patent, you're going to go to KIPI. KIPI is Kenyan
Institute of
Industrial Property Institute.
Yeah.
Yes. So basically, that is all about patents.
Patent
is all about inventions.
So the way we have high school students, the way the way you were in Miranda and I was in Chalks, and you'd come up with with something under the chemistry lab or not chemistry lab. I don't know, were they scientific
science projects,
Yeah, the science projects.
Science Congress and all that.
Yes. So when we come up with such things, or even shout out to my university, JQuat, where they also the engineering students come up with things. So now they should patent them. That is an example of what you're saying, patent and industrial designs.
Some of the stuff that are made in science congresses are made by maybe students.
Yes.
And some of them exist in the market. They are not entirely new.
Okay.
And so if you go to patent them and then they fail that novelty test, it means you would not be granted a patent.
Okay.
So even as we seek to promote innovation among the young students in high school going for science congresses, the threshold is set under the law.
Okay.
But you need to satisfy all these three.
How about the COVID-19 vaccine?
We are going to get to that. But now for the less simple inventions, the less complex inventions, we have this category of intellectual property called utility models.
Oh, yeah.
You can protect such less complex inventions through utility models.
Yes.
Other people have called them baby patents.
Oh, okay.
Because it's like patent, but for less complex inventions.
Okay.
So that is utility models now is like the third aspect of
that we've talked. Yeah. So I was asking about COVID-19 vaccine. COVID hit us, and could that also qualify as, can they patent it? I don't know which.
Yes, they can. But you see, the COVID situation was a matter of emergency. Yes. Many protocols regarding patents were broken. Okay. Just to have a working system.
Okay.
And luckily, this is some of the thing. This is one thing that we looked at deeply when we were doing the case for patents and global health, where basically we need to strike a balance, or rather, we are learning how to strike a balance between the inventor's entitlement to reward for the inventions vis-a-vis the public, or rather the right to the highest attainable healthcare.
Yes, it was.
So that is why it was necessary for some of these patents protocols to be broken in terms of application for a patent. You have come up with this drug. You need to be recognized as the inventor of that. Number one, it usually takes a very long time. But then now, since we are working in a period of emergency, we have to expedite it. So these are an example of some of the protocols that are
broken during that time.
But so long as it's an invention and it can be used to do something industrially.
Okay. Still a final aspect on patents. So the big pharma, yes. I'm sure you know what I'm talking about. So all the drugs we use, they are patented, or
yes,
it's not copyright, it's patent, it's not any other aspect of
it
the
is
IPs.
Not any other. I mean, you could protect them as your trade secrets. If you don't need to disclose them, there's another aspect of intellectual property called trade secrets.
Now that we're at trade secret, I'm sure most of us know KFC, Kentucky Fried Chicken. I don't know why I thought of something else. And they have a trade secret. They don't tell you the ingredients of what they use. Same case to Coca-Cola. They won't tell you what I don't know, is it the ingredients or the composition of...
Yes, the ratios of mixing the components.
Exactly. Yes. So please tell us more about trade secrets and whether,
Well, for something to be considered a trade secret, number one, it has to be commercially useful. You cannot have a useless information and then you want to protect it as a trade secret. It has to be commercially useful, and you must have taken reasonable steps to keep it discreet. You must not have disclosed this to anyone.
Okay.
So for trade secrets, and this is what makes trade secrets different from other types of intellectual property.
Mm-hmm.
Because whereas the others would need to be registered, you don't have to register trade secrets, because by registration, you are going to disclose. And if you disclose now, it's counterproductive to the very nature of whatever you seek to protect.
So how do they deal with the employees? They sign NDAs?
They sign NDAs, yes.
Non-disclosure agreements.
Yes.
Okay.
Yes.
Now we go to trademarks. I'm thinking of Nike. I'm thinking of a symbol. I'm thinking of, what are trademarks?
Well, a trademark is basically, it could be anything. It could be a name.
Mm-hmm.
It could be a symbol.
Mm-hmm.
It could be a slogan.
Mm-hmm.
It could be a logo, for instance.
Mm-hmm.
But one interesting thing about trademarks,
Mm-hmm.
and I believe many people have had this,
Mm-hmm.
is that for a sign or a symbol or a logo or a slogan to be protected as a trademark, number one, it has to be unique. Now this is different from patents, you understand? Because on one hand, patents need to be novel, but on the other hand, trademarks don't need to be novel. They just need to be unique.
Okay.
And then the second requirement for a mark or a symbol or a slogan to be protected as a trademark, it has to be distinctive. And by distinctive, it means that you have to be able to use that mark and ascribe it to a certain property or services or goods. Understand? So, for instance, we talked about KFC. You know, I mean, if you see KFC in red, you attribute it to whatever that chicken and the fries. And that is the hallmark of that is the essence of trademark.
All right. I love cars, Audi. So the circles, the symbols, I don't know, for the Audi lovers. I think the two circles there, I don't know if they are 5 or 4. Circles, yes. So are those 4 circles, because when you see the 4 circles, this is an Audi. Is that trademark?
Yes.
Or the name is the trademark?
You protect both of them. I mean,
or Mercedes with the symbol.
There are different classes of trademark. That is
okay.
The first thing. There's this system called, I think, the Madrid Protocol.
Okay.
Which outlines different classes of trademark. There are trademarks for I mean there are so many that it has escaped my mind. Okay. But there are different classes of trademark ranging from A all the way down.
Okay.
You have trademarks for maybe food. Okay. You have trademarks, food and foodstuffs. You have trademark for apparel and many other categories.
When you see Gucci, and there's also Dolce & Gabbana. Yes. There's so many. So when you see those symbols, this is...
Yes. And exactly, you see what you've said, your last statement is the essence of trademark. Okay. When you see those symbols, you attribute it to a certain brand.
Right.
Understand?
Okay.
Yes.
What have we not talked about? We've talked about patents, copyrights, trade secrets. What are we leaving behind?
There's another category of trademarks called industrial designs.
Okay.
Industrial designs, for the viewer, is basically concerned with the aesthetic appearance of any object that you can think about. For instance, that shape of a Coca-Cola bottle,
yes,
is protectable, and if you design, if you make a design of a bottle with a unique shape, it's protectable as an industrial design.
Okay.
And this applies to so many things. And
could you give us another example apart from the Coca-Cola?
Yes. Take an example, and I'm sure many people who will see this might relate. We have fashion designers, for instance. You get that this is a designer who is also a tailor, somewhere as random as Gikomba or Isili, and they have come up with a nice design for a suit. You see, half of the time they don't know what they're sitting on. They don't know that they can protect this design as an industrial design and then commercialize it.
Oh, I also didn't know that.
Well,
that's interesting.
That is the essence of intellectual property law. It seeks to create so many avenues for creative people to leverage on their creativity and make money out of it. So it's basically, it turns your ideas into assets.
Still at the tailoring one, because it has sparked my imagination and all that. Bolo Bespoke, I know, we all know him, and the way he does his suits and all that. If we say still thinking about industrial designs, or many other tailors who maybe copy from the Western, I mean Nigeria's, the way they do a lot of fashion. So if they copy from them, and we find that the Nigerians had already come up with registered whatever that design as an industrial design, so he'll have to pay them. Or I'm still trying to understand.
Well, not really. Okay, I think Bolo Bespoke is one of the most talented designers. I don't want to call him a tailor.
Yeah, he's a designer.
He's one of the most talented designers, and I believe he has a legal team that would advise him on such things. Okay. But another thing I have to mention is that intellectual property is territorial. Territorial in nature. So if we have an industrial design that was already popular in Nigeria, in the Nigerian underground, and then Bolo Bespoke discovers it. Finds out about it. Finds out about it.
It's not copying.
And then replicates it. I mean, where art is involved, it's usually said that replication is allowed. Even in music, there's sampling. So let's say Bolo Bespoke finds out about a certain design that is popular and unique and liked by many Nigerian people. You see, that design is not protected in Kenya. So when Bolo Bespoke registered that design, I mean, he will be registered as the owner. He doesn't have to pay them because they are Nigerians. And they are outside the jurisdiction of the country.
Nice, interesting. Now, probably we can now talk about the challenges. What are some of the biggest challenges facing IP in Kenya? Now that you said it's territorial, what are those challenges?
I mean, we have had so many challenges. And the first one I'm going to talk about is one that I've been talking about, I guess, maybe from 2019. And that has to do with the royalty collection.
True. For creative musicians.
Has been the most challenging part of copyright law, basically. Because whereas we have an elaborate framework in the Copyright Act, one aspect that has been lagging behind, or rather one aspect that has not been quite effective and useful for the musicians and artists, it's royalty collection.
True.
And this problem has been there for such a long time. I remember when I was writing about it for the first time and I was doing research on it, it is a problem that has been there from the 90s.
Okay.
Artists and musicians have been complaining about royalties from 90s through to the 2000s, through to the 2010s, and even up to date.
What is the issue with the royalties? They're not being paid by mdundo.com or Spotify?
No, that is not even the issue. The issue is collection and distribution. I have not had the privilege of looking at the numbers for 2024, but in 2023, for instance, MCSK, those who don't know MCSK, is the Music Copyright Society of Kenya. It collected 139 million shillings on behalf of artists. And then 10.5 million is the amount that was distributed. To the artists. Okay. So if you do the math, 10%, or rather 10.5 million divided by 139 times 100, this is like 7.4%, or rather 7 point something percent. And that is quite sad. Because take an example of this. The rationale for CMOs has always been that,
maybe you can tell our viewers what CMOs are.
Well, CMOs basically are collective management organizations. And the engagement between a musician, for instance, and a CMO is that the musician agrees with the CMO that, for example, during the period of 2023, from January to December, I'm going to allow you to collect royalties on my behalf. So the sad bit is that...
Do you have an example of a CMO in Kenya? Apart from... is Spotify?
No. A CMO is a collective management organization. And for an entity to be registered as a CMO, it has to be licensed.
By the
Kekobo.
Yes.
That is, Kekobo is Kenya Copyright Board.
Yeah.
So as an example of a CMO some of the CMOs that have been Kenya include the Kenya Association of Music Producers, that is CAMP.
Yeah, I've heard of it.
There has been PavRisk. Which other one? Yes, Frisk.
Yeah.
That is the one for performance rights. Performance rights. So the engagement between an artist and a CMO is that the artist cedes his authority to collect the royalties for many reasons. One of the reasons being a single artist cannot collect royalties throughout the country.
Okay.
But now the CMO holds itself out to have that capacity to collect the money on behalf of the artist. Now, take an example. An artist agrees with the CMO to collect royalties. So it's like let's use an example. If I'm an artist and you are a CMO, then I tell you, Angie, for the rest of the year, I need you to collect royalties on my behalf. And then at the end of the year, when you're supposed to pay me my royalties, you tell me that you collected 139 million, but you are only going to give me 10 million. Now the question begs, where is this balance? Where is this 129 million? What has it been used for? And when you look at the numbers from 2023, you find that this MCSK used like about 50 million, rather 57 million to pay its staff. It used another 16 million to pay the lawyers, like as legal fees. Now you can imagine, the feeling as an artist.
Yeah.
When you are not satisfied with a CMO, they use your money to defend themselves against you. You understand?
Yeah.
So when you look at these numbers, I think the only conclusion that you can draw is that these CMOs are not useful to the countries. And now that brings us to the next problem.
Okay, yes.
The first problem was royalty collection.
Yes.
The next problem now is that we do not have a framework for transition between CMOs.
What do you mean?
The law only recognizes one CMO in respect of a certain class of art. For example, I think, and this has been a debate among our circles as intellectual property lawyers, it's a provision, section 46(5) of the Copyright Act, which says that there shall only be one license in respect of one class of art. It means if MCSK has been licensed to collect royalties on behalf of musicians, there can be no other CMO collecting royalties on behalf of the same musician. And now that is the problem. Because when MCSK does things that are out of this world, that are unimaginable, such as paying artists 7.4 million, 7.4% of the gross royalties collected, and now the artists are dissatisfied and they need another CMO, or rather, when they get the license issued to MCSK revoked, what happens now?
Okay, so is that loophole. Also an issue of monopoly?
It's not monopoly per se, but now there's a loophole in the sense that once your license has been revoked as a CMO, you see, exploitation of IP or artistic rights never stops.
Okay.
If Kekobo revokes the license of MCSK, do you think that people will stop playing Kenyan music, for instance?
No.
Do you think people will stop listening to BN's music, for instance?
No.
That exploitation will continue for the period of revocation of license.
And
now that means no royalties being collected during that period.
Yes.
So, I've written before about transitional collective management of copyrights, where we propose that we need to have a framework where the artists are not satisfied with one CMO. We need to have a transitional period for when the license of that CMO has been revoked. How do we collect royalties for the artist during that period?
Okay.
You understand?
Yes.
Yeah, so that is the second challenge that we have.
And before you go to the third challenge, I think it's also important for us to understand and to get, for creatives, I'm sure videographers, musicians, they spend a lot when it comes to music production, and it's only fair that their rights are recognized. And I think this is a very important discussion. Maybe now we can go to the third challenge.
And now that brings me to the third challenge. It's the question of transparency and accountability.
Of what?
Of royalties, collection of royalties. You've seen severally when some of these artists come on social media, they say they spent 2 million in video shooting only. You haven't factored in the cost of...
No, let me now talk about WIPO. Yes, for WIPO.
Yes. I believe
actually said one.
WIPO has been very vocal about the cost of producing his videos. I mean, even when you look at them, you see the quality is just like
top notch. Yeah.
So imagine an artist like Willy Paul spends all those millions in the production of the music, video and audio, and then MCSK pays him 10,000 shillings. It's not commensurate. And now that brings us to the question: how much royalty really is collected in the country? And this informs one of the recommendations that perhaps we'll talk about later. We are saying that we need to come up with a system where collection of royalty is open, transparent, and there's accountability. One of the ways of doing this is maybe adopting blockchain technology.
Right.
Yes. And I don't know how easy this will be to understand, but for blockchain technology,
you can tell us.
And I believe whoever is watching this will agree with me 100%. That if we adopt blockchain technology, we are going to have a transparent system of collecting royalties. So for people who don't understand how we can use blockchain technology in collecting royalties, think of a notebook, right? This notebook, number one, it cannot be altered. Once an entry has been made, it cannot be altered. Number two, this notebook always tells the truth. It never lies.
Okay.
And this notebook, lastly, is accessible to anyone. You understand? Whoever you are as an artist, you can look at this notebook at any time. It is always accessible to you. It never lies, and it cannot be altered. So assume that now we are recording your entries, the entries for collection of royalties in this notebook. This will promote transparency.
True.
And accountability in such a manner that if MCSK comes today and declares it has collected 139 million, we just go back to this notebook and see. Is it really 139 that was collected? You understand?
Okay.
So, I mean, I have written about this before. I have shared it with them, and I hope if they watch this, they can try and implement. I mean, I believe the country has a lot of money. If we have 500 million to bid for Grammys, I believe we can come up with a system that can adopt blockchain technology in collection of royalties.
That brings me to probably our next question, and maybe before I ask it, with all these challenges, I think we can now see why maybe creatives or music, in this instance, I'll zone into musicians. We can see them now going for concerts or having, like, is it called performance rights, or I don't know what it's called, where
performing their music live.
Yes,
because it probably makes more money for them than royalties.
Yes.
I mean, that is true. That is very true.
And I think that's another avenue for them, because you can't be relying on the money you'll get from royalties, and you can actually go around and So my next question is
there are so many challenges.
Oh yeah, there are more challenges. Okay, give us two more so that we can.
There are so many challenges, and
we've talked about two.
We've talked about collection.
Yeah.
We've talked about accountability, and what else?
I don't know. Was it about the blockchain transparency and
Well, there's another one, and this I believe every viewer is going to relate to it. I mean, every viewer who has ever wanted to register their IP. I mean, one thing I would always recommend is that if you need to protect, or rather, if you need to encourage innovation in the country, lessen the cost for registering IP. Understand? Copyright registration is the cheapest because you pay 1,000 shillings, wait for maybe a few hours or days, get your certificate, and that's it. But when you look at other types of IP, the registration for trademarks, I mean, the earliest you can get a trademark is like 3 months. You understand? So it is costly in terms of time, and then it is also costly in terms of finances. In the sense that costly in terms of finances, in the sense that if you want to register a trademark, for instance, and you want to do it through an advocate, the least you're going to spend, honestly, is, I mean, if the advocate charges you fairly using the ARO, the least you're going to spend is like 90,000 or 100,000. You understand? So many people look at this and then they decide, no, it's not even worth it. Let me just use this mark as an unregistered mark. Because the cost of registration and the time I'm going to wait for that registration to be effected is just too much. Another challenge is lack of education on your IP, how you can exploit your IP, how you can enforce your IP, how you can register your IP, basically, and whether something is an IP. There's lack of education across the board in all aspects relating to IP. For instance, how many of these designers know that they can actually register their designs and commercialize? How many of these designers, or even how many of these musicians understand some of the rights that they hold? You know, IP even subsists when you create something as simple as whatever you can imagine.
Okay.
So many people do not know that whatever they are sitting on, or whatever they have in their hands, is actually IP that can be registered, protected,
monetized.
And monetized.
Yes. Still, yeah. I'm looking at something else in terms of a challenge for IP. When let's say I've not registered any of the 5 or so IP IP categories. Is there a challenge in terms of someone infringing on my rights, someone copying my work, someone stealing my idea? Is that also a challenge?
Well,
and running with it, taking it?
I want to give you a perfect example. I don't know if you are a fan of comedy, but recently there's this comedian called Flacco.
Yes.
He posted a video of one person preparing, or rather making a song, basically writing the song and rehearsing some of the melodies. And then there's this other character called Bakari was listening in, and then Bakari goes ahead to record and release the same music that this person was writing
before.
So when this other person was in the studio recording, his producer tells him that unajua nimesikia ngoma mahali. And then they realize that it's Bakari who had listened in and went ahead to record.
Yes.
So many people do not know that their IP exists until the same is violated. Understand? You do not know that your choreography is a big deal until you see someone else doing it commercially.
Yes.
You do not know that that painting that you have at home, rather wherever, anything you have is useful until you see someone else using it commercially.
Then you say they stole my idea, but you didn't register it.
So, and on that note, I have to reiterate that IP protects not the idea, but the expression of the idea.
Exactly.
And that is the perfect example of this guy who was writing music, and then Uncle Bakari went ahead to record and release. You understand? What he was doing was like he's just trying to make the melodies and write the lyrics. At that point, it's still an idea. It's not a song.
Yeah.
But when Bakari records it as a song and produces it and releases it, now it becomes a song. It becomes an expression of that idea.
And that is what the law protects.
Exactly.
Right. Interesting. So what, in terms of creators, I think we've talked about creators a lot. And maybe you can still touch on whether you think they are aware of their rights. You've talked about it, but you can still stress and insist that creators need to know their rights.
And that is the essence of the legal aid that we are going to organize on 15th of May for a whole month.
Yeah.
We've done this before. I think in 2023 we did one. The turnout wasn't as much because we had not grown as much as we have now.
You're talking about the Center for?
Yes.
Maybe you can tell our viewers
the Center
again.
The Center for Afro-IP Law and Policy Research. It's basically a consultancy that promotes intellectual property law and policy through research. So this legal aid is useful to us in the sense that we are going to give back to society by dispensing knowledge and
immense
counsel.
Knowledge.
Yes. Knowledge and counsel relating to intellectual property law, touching on all the matters that I had mentioned earlier. And also, it gives us an opportunity to carry out an in-person research with the actual artists to know what are some of the challenges that they go through. What are some of the opportunities that are out there. So we strongly encourage all creators.
Yeah.
All creators of musical works, artistic works, inventors. If you have a mark that you'd like to protect and you don't know how to go about it, you have a whole month between 15th May and 15th June to come for free legal consultancy. And this is going to be very simple. You send us an email and book an appointment. And then we can do it with you virtually, or rather we can even do it physically as well, depending on your availability and depending on the amount of counsel that we would need to give you.
Okay.
So this is very artist-centered. This is very artist-centered. And we call upon everyone who is in need of legal counsel touching on IP to send us an email. I believe Angie will share our email address when this video is released. Yes.
I would really like us to know, and maybe you can tell our viewers, what are some of the positive trends or innovations happening in regards to IP? And maybe I'll give you a context. And this is just to throw it out there. There's the issue of artificial intelligence that has taken the whole world by storm, I guess. And in US, I think we all know Drake. And he came up with, he's a musician. I'm sure most people know him. And some guy somewhere used AI tools to create or to mimic to create a song using AI that mimics the voice of Drake, and it went to and the song I think blew up, and people thought it was actually Drake singing, which is so interesting. So the issues of AI, but eventually he went to court, and I think he was paid damages, and the song was pulled down. That is with regards to AI. So maybe you can now tell us in your own way, and give us maybe examples of the positive trends and innovations happening in IP.
Well, regarding artificial intelligence, one of the key recommendations that I would actually make now that AI has taken over, or rather is taking over, I believe AI would be useful in when you go to register, or rather when you make an application for the registration of an IP, for example, a trademark or a patent, there's usually a search that is done before that application is considered.
Yeah.
The search is important to find out if there are any existing, or rather if that mark is already existing. And it usually takes some time. So I believe we can leverage on AI to come up with a database of all registered trademarks, so that when you go to register, your application is just looked at and put into this AI system, and then scans it in real time, and then a search is done for you in a matter of minutes.
Okay.
So this is one of the areas that we can consider incorporating AI into. That will simplify the time and I believe the cost because I believe the cost for registration of IP basically.
What other innovation is there with regards to IP?
Another trend,
or a positive trend?
Well, a positive trend, and this is actually, I hope it yields good results for creators and inventors in the country. There has been this proposal to merge KIPI and Kekobo and the anti-counterfeit authorities.
Yes.
So I trust that when now we have this new entity that will be managing IP and industrial property generally, we are going to come up with a robust system that has sealed all the existing loopholes. In terms of now it will be easier for creators and inventors to register their works. It will be much faster for them to obtain the certificates. And basically make life easier for any creator and encourage people to create and innovate more.
True. So what are the changes that need to be done to improve IP in Kenya or IP protection in Kenya?
Well, in a nutshell, I think for copyright holders, they would agree with me that we need better royalty collection and distribution. And if you ask me, if it were up to me, I would recommend that before an entity is issued with a license, let them give certain undertakings to the artist. For example, if we collect 139 million, we are going to give you at least 75% of it. Understand? Because now that is one of the things that make the CMO useful. Because an artist cannot be recording music for a whole year, spending millions, and then at the end of the year they get 10,000 shillings.
It's quite embarrassing. Yeah. Are there any changes you'd suggest to improve IP protection in Kenya?
Yes, definitely. And I've written about it severally. Transitional management, for instance, where in the context of CMOs and royalty collection, we need a transitional framework where one license is revoked. We have a transitional provisions for the period in which within which that license is revoked. How a royalty is going to be collected and distributed during that period.
I'm thinking about supermarkets. You know, when you go into supermarkets and there's music playing, or when DJs in clubs play music, are they infringing on someone's copyright, or have they paid for that?
Yes. There's a joint license issued by, I think, MCSK and two other CMOs. And if you intend to open such an outlet, a bar or restaurant, or even a supermarket, they usually take out those licenses. Right. So they are not infringing.
So when they pay, now, does that form part of royalties?
Yes.
It does. Interesting. What does the future look like for IP law or IP protection in Kenya?
I mean, it's a good thing that people are talking about it, including musicians and artists. And in our capacity as lawyers, we are giving legal counsel to people across the country. So if we continue on the same trend, I think the future of IP is bright. Also taking into account the infusion of artificial intelligence and other forms of technology such as blockchain technology, we are going to invigorate our IP systems.
Okay.
And lastly, as I said, we look at the future with hope, because we trust that this new merged entity that is as a result of the coalescence of KIPI, Kekobo, and ACA is going to come up with a better system that is beneficial to creators and inventors.
So before our closing remarks, before our final remarks, maybe you can still, I'm really interested about the AI issue and how people can use AI to infringe on other people's rights. Because I'm thinking, let's say, you see, there's this painting, the famous painting by some artists. I've forgotten the name. It's a very unique Da Vinci. And maybe I'm just giving an example. Then I use AI to draw something, or someone has done their work, and then I use AI. I'm just trying to imagine. I use AI. So I really want to understand how AI I feel like can be a good servant but a very bad master in terms of it. I think it will propagate a lot of copyright infringement. What are your thoughts on that?
My thoughts are that as AI continues to be proliferated in our society, we have to come up with the regulatory mechanism. Some of them are there. Some regulatory mechanisms are there in the sense that if you violate an existing copyright, then you are liable to pay damages, or rather to compensate the original owner. And behind every AI instruction, there's a person issuing the command. AI does not just create. For instance, that GPT would not just out of its own volition make a painting, or rather replicate a painting. There has to be a command. So the question is, who is giving this command?
I'll sue that person.
Exactly.
We'll probably sue them. So in your closing remarks, maybe you can also tell us how IP is infringed, or defenses, the defenses to copyright infringement and all that. Can I say, if I mention someone in my music, or can I say I was using it for private use? Can I say probably it was for scientific, it was for education? What are the, as you give us your final remarks, what are the defenses? I want you to play the devil's advocate. What are the defenses if your client has actually infringed copyright? How would you defend them as you wrap up and close the session?
Well, I think for context, we are talking about copyright.
Yes.
The rights, or rather copyrights, the provision for copyrights are found under Section 26 of the Copyright Act. And then the exceptions are found under the second schedule of the Copyright Act. So under the second schedule, there is fair engagement, also known as fair use. Yes. Or fair dealing. You can take someone's work, and then if you're using it under, or rather if you're engaging with it under fair use, then there's no infringement. For instance, if you're using it for scientific research, if you're just giving a personal review of it, what is the other exception? I mean, there are so many exceptions. But the idea is that if you are using it under fair engagement or fair use, there is no infringement.
So if I play music,
most importantly, there's that bit of acknowledgement.
Right.
If let's say, let's take an example of Bien's lyrics saying, "Kipara bila pesa," something. If you use that in your music, you need to acknowledge Bien.
Okay.
If you use that line and acknowledge that this is Bien's line, then there's no infringement.
All right. And if I play music in my house, that's private use. I'm not a DJ, so yes. I wouldn't be charged to.
If you play it outside the normal circle of friends, then that becomes an infringement. Yes.
What are your final remarks as we close?
On
the whole
on IP or on the podcast?
Everything.
Well, I would have to congratulate you, number one, for coming up with this platform. It goes a long way in the sense of they say information is power. Yes. And what we are trying to do here is to pass information to the masses. Yes. Legal information, which not many people have.
True.
Understand? So congratulations, and I commend you for that.
Thank you. All right. So as we end, you already know the drill. We have a shirt. So this is one of the shirts by Print Mzuri Apparel. I'll be gifting our guest speaker today. This says Sheria Clinic. Then at the back, it has our logo. We normally read it together. Yes. So it says, serving you legal insights.
Serving you legal insights
in the simplest of ways. So here goes your shirt.
Thank you.
Thank you so much for accepting to be part of our session today, and being IP Day. It was such an informative discussion. I keep saying this. I've also learned a lot. Yes, and we'll definitely go back to this video to even take notes. Yeah, it has been very interesting. I'm glad that you are here. So that has been it today. It was World IP Day. I hope that you have learned a lot, and you'll continue engaging with our content on YouTube. We're also on TikTok. We're also on Instagram. You can follow us, like our page, and support us. As we have said, we'll be holding either webinars or legal aid with regards to IP. So be on the lookout for that. We'll announce on our different platforms. That's the end. Thank you. Have a good day. Bye.